Well, good evening and thank you for joining us. Not sure what's going on with the computer here. Give me 1 second. These are some of the challenges of live town hall presentations, but I want to thank you for joining us this afternoon or this evening. Whenever you're watching this, it may be a recording at a later date, but my name is Michael Gault. I'm an eminent domain lawyer with Bell Carrington, located here in South Carolina. I'm going to enter my name, email address, and our firm's eminent domain website into the chat box. So if you have questions that I don't address here this evening, or you want to reach out to me directly, I'd invite you to do so. We are here this evening in our weekly installment of our virtual town halls to talk specifically about the 526 Long Point Interchange Improvements Project. As many of you that are likely impacted landowners know, this project is funded and going forward, and we are in or getting into the right-of-way acquisition phase. Many of you may have already received contact. Some of you may have already received offers, but we know that that process is moving forward. And as eminent domain attorneys who represent landowners, we like to get ahead of these projects. We like to let landowners know who we are and what we do. And we found that these town halls are beneficial for that. So we appreciate you joining us, and I'll jump right in. In looking at our impact assessment map, we see that nearly all of the impacted parcels on this project are either commercial or industrial. In many road improvement projects, you have a mix of residential impacts as well. Obviously, each of those different types of properties present unique challenges for an eminent domain attorney, but I'm going to tailor this one slightly more to commercial and industrial impacts because of the nature of the project and the surrounding parcels. When you look at the project map here, you see that there are a number of new routings and then some improvements alongside of existing roadway. Some of that is needed. We've seen that the state has presented the need for this improvement project, and I certainly get it. I understand how Charleston has grown, how the port is growing, how the Wando terminal is growing, and this area is in need of some interchange and intersection improvement projects to keep up with the growing demand. Unfortunately, for many of you landowners that may own businesses or vacant parcels along this stretch, that means that some of your property may be acquired or required to complete the project. And the government has the ability to do that as necessary. That is known as the government's right to eminent domain. In projects like this, you may hear governmental officials, DOT officials, or county officials, or otherwise say that we hope to not use eminent domain. And that's true, but that doesn't mean that your property is not required for the project's completion. That just simply means that they hope to be able to reach a settlement with you before they have to use the power of eminent domain. But overall, this is a project involving eminent domain. Likely, at some point during the initial inception of this process, you'll be contacted by a representative who will let you know exactly what is needed. There will probably be an appraisal undertaken, and at some point, you're going to receive an offer. In many cases, I don't mean to ever throw the government on the bus or accuse them of being underhanded by any means. They're not. I think that everything is above board, typically speaking, in this state and in these types of projects. But usually, the true impact to the value of the property is not presented adequately in the offer and the appraisal that the department makes to you initially. Oftentimes, the true determination of what the impact to your parcel may be requires more digging. It requires additional expertise. And that's where our firm comes in. We are a team of eminent domain lawyers that represent landowners, commercial, industrial, and residential across a number of states in the Southeast. I happen to be located in and focus on South Carolina projects and cases. And so this is in my backyard, sort of in my wheelhouse. And in that role, we represent landowners day in and day out in determining the true impact to the property and advocating against the governmental entity, in this case, the DOT, to make sure that the landowner's rights are protected. You, as a landowner, have a number of rights in these cases that may or may not be explained to you and that you certainly may not be aware of if you haven't had to do these types of cases before, and I hope that you haven't. But among the most important of your rights is the right to just compensation. And that just simply means that even though the government can take your property in many cases to complete a project for a public purpose like this, they have to pay you fairly and adequately for what they're taking from you. Like we mentioned earlier, though, that determination is not a simple mathematical formula. You can't do A plus B equals just compensation for the landowner. Instead, it's more of an intricate art-based approach. Find out how is access changing? How will the elevation changes maybe happen in the after? Do I have full access or right in, right out only? Does visibility change? Will my landscaping or signage be impacted? And then even after you develop all of those potential damages to your property, there's a challenge, and that's in advocating for yourself and negotiating on your own behalf to see that the money is actually paid by the government. Sometimes that's the hardest part. It takes experience to put together counteroffers and to negotiate throughout the process to make sure that just compensation is ultimately realized at the end of the day. Skipping forward, if that negotiation process fails, ultimately the government then uses their true power of eminent domain through what's known as condemnation. That has a number of different connotations to it, the word condemnation. Some people think about dilapidated properties. Some people know that it means that the government can take property, but they think that it means that once condemnation filed, that the deal's over. You either settle before condemnation or they're just going to take it and you'll get whatever you want to get. In South Carolina, fortunately, that's not true. You, as the landowner, have the right to fight through the condemnation/litigation process. You have a right to present your case for a lawyer that is assigned to represent the DOT. And there are a number of steps during that process that might allow you and the department to be able to settle these cases. But ultimately, if you're unsuccessful in that negotiation, then you have the right to a jury trial. You have a right to seat 12 jurors who can hear the case, and they will ultimately decide the amount of compensation that is owed. So it's not a take it or leave it deal. Although we like to settle cases, we feel like there's oftentimes benefit in the certainty that a true negotiation and a resolution through settlement get you. But if not, we're prepared to try those cases. And we have a team of lawyers that are able and have done that and are well versed and familiar with the process, the procedure, the terminology, and the players involved. So just to recap, we're here to help you. What we do all day, every day is representing landowners, both commercial, industrial, and residential, in identifying damages to a property as a result of a project like this. We feel that we are able to offer some experience when it comes to eminent domain impacts to properties, and certainly through the condemnation process, where certain landowners may not feel comfortable and may not have the experience necessary to reach the same outcome that we could reach. And we have a fee structure at Bell Carrington that makes it beneficial for landowners to work with us to achieve that just compensation. It's a little bit unique. It's a contingency fee structured where our fee is a percentage of the amount recovered over and above the amount offered. So we don't ever ask for out-of-pocket fees or expenses. We don't bill you hourly. There are no retainers due. And ultimately, if we're not able in identifying and increasing the amount of just compensation owed to the landowner, then we're not in a position to charge the client any attorney fee on those cases. Now, that's a blanket statement. Obviously, individual cases can have certain different fee structures or impacts, or sometimes we're happy to work with the landowner, especially a commercial or industrial landowner, to develop a unique fee structure that works for them. But that's a blanket statement. Now, what I would invite you to do is to reach out to me directly through an email or on our landing page. You'll find a number of ways to schedule a consultation with us where we can really dive down into the impact to your property. We have some software that will allow us to do that. We can see the impacts in real time, and we can talk to you about what we believe the impact might be, how we may be able to help. And during that conversation, we can certainly come to terms on what a particular fee structure might look like with our firm and with your impact. So again, Michael Gault with Bell Carrington. We like to keep these things around 10 minutes. I know that's generally my attention span, so I appreciate you being here. And I would invite you to reach out to me or someone on our team so that we can look at the impact to your property and walk with you and hopefully work with you throughout this project and this process. Again, thank you very much. Look forward to seeing you.